Is up there. All right, so Senator Freeman, one, I want to thank you for pointing out the incident that you had talked about as far as, you know, products being used that relates to fentanyl. I mean, there is definitely a way that, you know, that I've advocated for, which would be much more regulated way of those products, vape products, different discussion, but I do want to thank you for bringing that up. But I do want to
We're not legalizing marijuana today, tomorrow, or the next
still time.
day.
I mean, we still got some time.
I'm going to go home, Senator Pol.
You can. I mean, so.
I know you would like that, but.
I want to point your attention to conference committee report on the first page. It's talking about, you know, subsection C under section 1. You know, I guess section 3.4 if you're looking at the code section. But it talks about a violent arrestee or repeat violent offender would only be released on bail set individually by court. The following hearing held in open court before releasing the violent arrestee or repeat violent arrestee on bail, the court must, and then it has subsections 1 and 2. It's got to review the probable cause affidavit or the arrest warrant and impose a money bail payable by surety bond or cash deposit. Now, you and I, we practice in the courtroom, correct?
Yes.
So, if we're talking about, you know, the issue of bail, and what we've listed here seems to be an exhaustive list because it doesn't state, for example, that these are things that could be reviewed, but ultimately it states just the probable cause affidavit or the arrest warrant. Would you agree with me that other things are essentially not covered, such as evidence from the defendant themselves or the arrestee themselves?
I agree. So if we're going to, are there other things the court can consider? I don't think in any way this says that the court can't consider those things. I appreciate if you're saying there should have been other things on the list, but I don't think the court is precluded in any way under this language from considering whatever a defense lawyer is going to bring in and present to a court. So,
for example, I mean, and I think that's kind of what my issue is with the language. I know you and I talked about it. You know, things have happened very, very quickly here towards the end of session. But ultimately, I mean, would you agree that it would be appropriate to potentially listen to evidence outside of just the probable cause affidavit written by a police officer, correct?
Sure, and I think the court has that discretion.
Okay. My concern is that we don't necessarily spell out that discretion that's listed here, and that a court might say, ugh, I'm stuck here between either looking at the probable cause affidavit or an arrest warrant.
No, look, I think we're saying the same thing, just you would like it spelled out. What is clear is that unlike what's happening right now in some parts of our state, these folks, and only these folks, I mean, I would hope we could agree that these are, to use the worst of the worst. I mean, these are folks that need to be considered by a court before they're released on bond in any way. And the court's going to consider a probable cause affidavit, and they can look at anything else they want. They have the discretion to do that.
See, I think that's where I struggle with it, because I don't see the discretion that's listed there, and that my worry would be that a court would essentially foreclose an argument that if an individual did want to defend themselves and say, Judge, you're only looking at the affidavit or you're only looking at the arrest warrant, a judge could say, by looking at the language that's specifically here, I'm limited to just these two things. And it's not even both of them. I mean, you could essentially argue, well, the arrest warrant, you know, and the probable cause affidavit are actually in conflict. Well, the judge would pick one or the other. It doesn't state that they have to review both of them, or it doesn't state that you have to review like a risk assessment tool or anything else as it pertains to an individual that's either, you know, that's been arrested for a violent crime.
Senator Pol, you know my love of statutory construction and my love of Justice Scalia, and this doesn't say the court may only consider or the court shall only consider. If I had intended it to only be a probable cause affidavit or arrest warrant, it would say the court may only or shall only review the probable cause affidavit and arrest warrant. That's not what it says. It says, I want the court to look at these two things, But the court is more than welcome to look at anything they want in considering what the bond's going to be for this person.
And I think in other parts of the code, we provide for that. And you and I had a discussion about judicial discretion the other day on a completely different topic, and you and I are 100% on the same page as that.
I agree.
So I think that in other places in the code, we are a little bit more clear as to when judicial discretion applies. I think that's my main concern here, is that this does not seem to provide that. And I know that you're reading that into it, and essentially what we're leaving is the potential for a, as you would put it, an appellate attorney to have to make that argument later, as opposed to a trial attorney having that argument right there on the floor.
I was told earlier by one of my colleagues, I'll see you in 8 months.
Well, that's my question to you then. I mean, you know, assuming that this does pass, would you be willing to work with me to essentially fix this?
I'm always open to work with you on anything you want, except for one issue that we don't agree on and we're probably never going to agree on, and that's okay.
One of these days, I'm going to get the best of that. I promise you. I promise you.
Good for you.
The other thing that I was going to ask as well is, you know, as far as bail goes, I mean, I think that you would agree that, I mean, if an individual is denied bail, that's a pretty seismic change for that person. They're essentially going to be held without.
But I disagree with your premise of your question, because they're not going to be denied bail. They're going to get bail. The court's just going to, A, hold a hearing. Yep. They're going to consider these things, and then they're going to impose either money bail or surety bail.
Oh, you're jumping to a conclusion. I'm not saying that there's the potential for either denial, you know, what you're doing here is you're requiring that there's a bail hearing, and that
yes.
Of that, there may be bail, there may not be.
There's going to be bail. See, I'm very prescriptive, see? So go to page 2. The court's going to impose money bail payable by surety bond or cash deposit.
Correct.
So we're not giving somebody bail.
So, and I agree. I think, but to my point, and you're
telling me I'm right.
You're going to
go ahead.
You're going to one section of this where I'm thinking of this more generally. So if bail is set because they looked at the arrest warrant and the probable cause affidavit, and they said, okay, we think you started this bar fight. We're going to set bail at $100,000, and that individual sitting there can't put on their own evidence. They're trying to make an argument. They don't know that they can make the judicial discretion argument that you were, for example, making, and saying, Your Honor, I think I should have the ability to defend myself here outside of what was, you know, prescribed by a police officer who wasn't there, that just kind of took some statements and put it in a probable cause affidavit. Do you think that that individual should be provided counsel during that bail hearing?
I have no issue. I mean, if they're indigent.
If they're indigent.
That's a big if.
So would you be willing?
Because there's parts of the state that everybody gets the public defender. But if you're indigent and you cannot afford counsel, of course, I believe everybody should have the right to a public defender.
At the bail hearing?
Sure, absolutely.
You'd be willing to work with me on that?
Happy.
Saving the state. Somebody mark that. All right, thank you very much.
Thank you, Senator. Further discussion, Senator Kadora.